grand jury took the kind of time that it took to try to get to the bottom of this. Members of the community have expressed, as they should, their concern about the death of a young child in their community. We wanted to make sure that our investigative efforts led us to the person who inescapably, we believe at trial, will be shown to be the responsible party and the guilty party for killing Kayla Peters. And more importantly, it is an object lesson that we need a grand jury to compel people's testimony when they otherwise might not be coming forth to do so. We lament the death of Kayla Peters, and we are also determined to make sure that she and her family, as other families similarly situated, get the kind of justice that they deserve. We are enormously grateful for the efforts of Dave Augenbraun and the other people here who presented testimony, Mr. Gilson, Mr. McCann, the police department, and everybody who helped us in this investigation. Patience does pay off, and it comes at a price of being a little more sure in the community's mind that we have done the right thing by convening this grand jury. I'm convinced beyond all doubt that this was the right thing to do and was totally appropriate in this case. We'll try to take any questions we can. Remember, you've been provided with the presentment. We cannot go really behind the presentment. We do want you to know, however, that our Chief of Homicide, Mr. McCann, has been in touch with Ms. Goyman's attorney. She is going to accede to the addition of the other charges. The bail will stand. However, we understand from further information from the neighbors of Ms. Goyman that her house is up for sale. Her mother may be living in it, but we believe that Ms. Goyman may not be living in it. We want to assure ourselves that even though we have Ms. Goyman's passport, that she doesn't try to leave the jurisdiction or conceal her whereabouts for any reason whatsoever. So I've asked Mr. McCann to get to Ms. Goyman's attorney to find out where she's living right this moment and where she intends to be living throughout the pendency of this case. And we'll be pleased to take any questions that we can, consistent with the information I've given you previously. Yes, sir. Could you give me your name, please, so I know who you are? Yes, sir. Where she's living, we'll give you whatever information, sure, that we can give you. Well, there are, as the presentment indicates, first of all, Ms. Goyman made statements herself that she believed that she had killed somebody, that she was driving down the street after leaving Tartufo upon dropping Mr. Del Bello off, that she heard a thud. She claimed that something hit her car, not the other way around. She hit the child didn't hit her. And that she drove off, and that the next day she heard on the news that this young woman had been killed on the street. She immediately believed that she had killed somebody. So she made that statement at least once to at least one other person. We also know from the evidence brought before the grand jury that Mr. Del Bello testified that she was driving that car. And the time period when she was at his bar restaurant, Tartufo, the time she was at Thomas's bar, and the time that she was at Kildare's bar on Main Street in Manioc, all within a short distance in time and place of each other, that she was drinking that night. And that given the time, distance, location, and all the other factors from all of the evidence produced, it's our belief, plus there are additional witnesses who testified that a dark-haired woman alone in a car was just speeding at a terrifically high rate of speed down Ridge Avenue. The witness heard a thud and a loud sound. In fact, he thought that the white car had hit another car. Turned out that was the sound of Ms. Peters' body smashing into Ms. Goyman's car upon being struck. And that information, we believe, is not a preponderance. We believe that's evidence beyond a reasonable doubt that she was driving the car. We'll see what the jury thinks. Not what we think. If you think you hit something, you stop, You put your car out of gear, you get out of the car, you attempt to render assistance, you call the police, you stay there until the police arrive, and whatever it is, that's what it is. You don't flee the scene, go to bed, watch television the next day, know that you killed somebody, and call people and tell them, I think I killed somebody. We can't yet say what charges anybody else will possibly face. We'll see how that plays out as this entire case unfolds. Anything is possible in life, right? But we're not exactly in a position right now where we want to discuss that. Mr. Del Bello did testify in front of the grand jury, and there was no immunity asked for or granted. So his testimony is of record. Yeah? Sure. Yes. Well, we understand, and I understand personally, how communities feel when some terrible event happens in their neighborhood, whether it's a homicide by shooting, a terrible crime that offends and affects the community. It happens every day. We understand that people want results right away. Sometimes it's not possible to get results right away. We thought that in this and other cases, including unsolved homicide cases by shootings and other kinds of crimes, that an investigating grand jury is an appropriate way to go. And we have used investigating grand juries in many cases. It does take time, however, and people grow sometimes impatient. And they, I know, are pleased when the result comes. They always want it sooner. Everybody wants everything sooner. Here's where we balance the desires of a community and our needs to make sure that our evidence is correct. We don't want to rush to judgment. We don't want to just push things to satisfy the community and find out later that we come up short. So we are sympathetic with the community. We know how unhappy and angry they were, and we understand that. We just have to make sure that we went out to the community, which we did, and told them to be patient with us, that we would do as much as we could, as quickly as we could. And this is the upshot of it. An investigating grand jury has returned these presentments charging Ms. Goyman with the crimes we're charging her today. If we had not done that, we wouldn't have gone in the direction and at the great distance that we've gone in this period of time. Yes. The penalties for the crimes are for homicide by vehicle, that's a felony of the third degree. The maximum possible sentence is 3.5 to 7 years. For homicide by vehicle while driving under the influence of alcohol or drugs, it's a felony of the second degree. The sentence is 5 to 10 years with a mandatory minimum sentence, 3 years imprisonment. With driving under the influence, it is an ungraded misdemeanor with a possible penalty of 6 months. With the previous crime, the felony third degree, leaving the scene of an accident where death or serious injury occurred, that's a 3.5 to 7 year maximum sentence with a 1 year mandatory minimum sentence required. Well, she's looking at a lot of time. If you want to add up the mandos plus other sentences, it's a lot of, it's a significant amount of time. However, no amount of time that anybody is sentenced to prison ever makes up for or recompenses a family who's lost a child to violence. So, can I tell me your name? I'm sorry, Joe Rose. Current whereabouts of, we believe she's somewhere in the Philadelphia area, but where she is specifically right this moment, I don't know. We will ascertain that. Mr. McCann is going to be contacting Ms. Gorman's lawyer to make sure that we know exactly where she is, not where she may be today, where she may not be tomorrow. I personally do not want her leaving this jurisdiction. In other words, I want her confined to the city and county of Philadelphia. I don't have to go look for her or ask her to come in. She should be in the city and county of Philadelphia. We're going to see to it that a court makes such an order. The court will accede to our wishes. No, she doesn't have to. There are two ways to do this, Mike. A defendant can, if the defendant wishes, agree to the new charges and not have to go through the fingerprinting photograph in which she's already gone through. Or the defendant can insist that, okay, I want to go through the roundhouse again. There are very few defendants, no disrespect is intended to the police department, who want to go through the roundhouse, nor is it necessary. So when we make rearrests in the courtroom, we say to the defense attorney, do you want your client to go through the roundhouse again? 99 times out of 100, if not 100 times out of 100, they say, thank you, we'll waive that. We agree to the addition of the charges, and we'll just keep it the way it is. No question about it. All homicides except those homicides where possibly the death penalty is involved are unbailable, plus under the newest constitutional amendment, which I fought for, where the judge is convinced that no controls on the defendant or series of controls upon the defendant will keep the community safe, will prevent her from fleeing, then the judge can, in his or her discretion, order that the person be held without bail upon proof established by us that no combination of conditions or any single condition will make sure that the community or the witnesses are safe. Correct. We understood at the time that that was her place of residence, and I believe that's the residence that she gave. As you know from prior reporting, her restaurant has now been sold. Her house is presently up for sale. We want to know who's living in that house, and it is not she. And if she's not living in that house, where is she living? We just need to know where she is at all times, consistent with bail. That's what bail is for, to know where she lives, where she resides, and so that the police or the court process can be appropriately served. We're reasonably certain that we will get this information in short order, and we'll share it with you to the extent we are permitted to do so. Neighbors in the past couple of days have advised us that they don't believe she's living there. I haven't been out to that house. I cannot attest to this from personal information myself, but like any other information such as that, we want to make sure that we know what we're doing. If she lives there, and she assures us she's living there, and our lawyer attests to that fact, we'll accept that. If she's not living there and the neighbors don't think she lives there, we have to find out where she does. $300,000. Oh, $200,000. $250,000. Thanks, Ed. $250,000.
And will be charged when we get to talk about this.
Well, unless we are convinced that she is a flight risk. We were initially, as you may recall, Mr. Abrams, concerned that because she was in Florida with her family and she comes from Venezuela, I was personally concerned, as the police and our prosecutors were, that she might attempt to flee to a foreign country. We have to go through all of that. And fortunately, we were able to secure her attendance here through the cooperation of her lawyer. We asked for and received her passport. We've conducted appropriate precautions with the Immigration and Customs Enforcement Agency by asserting that we required her surrendering her passport so that she couldn't apply for another passport claiming it was lost, which sometimes happens. So she can't get another passport. At least we've taken steps to reasonably assure ourselves that that can't happen. And we don't believe at this point, absent other information coming to us, that she presently presents a flight risk, but we're going to take every precaution to make sure that she's not.